Did you know that in just 1 month, over 2,000 people were deported from Australia, some without even realising they had broken the law? And now, with new immigration rules coming into effect this October 2025, thousands more could face the same fate, including students, workers, and even long-term residents. That's right, you could be deported for something as simple as working a few extra hours, posting the wrong thing on social media, or forgetting to update your home address. Sounds extreme? Maybe. But it's happening. Australia's immigration system is changing fast, and what used to be a minor mistake can now lead to instant deportation. The worst part? Most people won't even see it coming until it's too late. So in this video, we're breaking down 10 shocking reasons people could be deported under the new laws. Some of these will seriously surprise you, so make sure you stick around till the end. Number 10. Being associated with banned organisations. This one might sound like something from a spy movie, but it's very real, and it's already affecting people living in Australia. Under the new 2025 immigration enforcement rules, simply being associated with a banned or high-risk organisation could be enough to get your visa cancelled and trigger immediate deportation. Now here's the scary part. You don't need to be an official member of these groups. Just attending an event, donating money, or even liking a social media post linked to these organisations could put you on the government's radar. Authorities are using AI-powered monitoring systems to track online behaviour and cross-reference it with known extremist or politically sensitive groups. This is especially targeting individuals from regions with ongoing conflict or political unrest, but it can apply to anyone in Australia on a temporary or permanent visa. Even unintentional connections, like sharing an article or joining a WhatsApp group, could be misinterpreted as support or involvement. The Department of Home Affairs has made it clear, if they believe you pose a risk to public safety or national security, they won't wait for a court trial. Your visa can be revoked on character grounds, and you could be removed from the country within days. So what should you do? Be extremely cautious about the groups, causes, and pages you support, online or offline. Stay away from controversial gatherings, don't engage with suspicious content, and never donate to organisations unless you've verified they're fully legal and registered in Australia. This rule is as vague as it is dangerous, so better safe than sorry. If you found this tip helpful, hit that like button, drop a comment if you've heard of similar cases, and subscribe for more must-know updates about Australian immigration changes. Number 9. Not updating home address or contact info. It might seem like a small oversight, but under Australia's updated immigration regulations, failing to update your home address or contact information could now lead to visa cancellation and deportation. Yes, something as simple as forgetting to notify the Department of Home Affairs when you move house or change your phone number can put your entire immigration status at risk. Here's how it works. Every visa holder in Australia is legally required to keep their contact details up to date in their IMI account or through formal channels. This includes your residential address, email, and phone number. These details are not just for routine updates, they are how immigration authorities communicate important notices, including visa renewals, compliance checks, or even deportation warnings. If a notice is sent to your old address and you don't respond in time, it may be taken as a failure to comply, even if you never saw the letter. Authorities consider unresponsiveness as a red flag, and in some cases, they may assume you've left the country or are deliberately avoiding contact. This can result in automatic visa cancellation without further warning. What's even more alarming is that many people don't realise how strict the system has become. With new digital enforcement tools, immigration officers are now cross-checking addresses with banking data, tax records, and even utility bills. If your official records don't match, you could be flagged for investigation. This is particularly risky for international students, backpackers, or those on bridging visas who move frequently. It's also a growing issue among people living in shared housing or temporary accommodations who forget to update their details. So while it might seem like a small administrative task, keeping your contact details updated is now a critical part of staying legally in Australia under the October 2025 changes. Number 8. No English proficiency progress. This new rule is catching many visa holders off guard, especially those who've been living in Australia for a few years. Under the updated immigration policies effective from October 2025, individuals on certain long-term temporary visas are now required to show reasonable progress in English language proficiency. If they fail to do so, their visa may be cancelled and they could face deportation. The goal, according to the government, is to ensure better integration into Australian society, improve job opportunities, and enhanced community safety. But in practice, this rule is affecting people who may have simply been too busy working, raising families, or unaware that language learning is now being closely monitored. This particularly applies to people on partner visas, bridging visas, and certain types of protection or humanitarian visas, where the assumption is that over time, they should be able to demonstrate some ability to communicate in English. So what counts as reasonable progress? That's the tricky part. It's not just about sitting an IELTS test or passing an exam. Immigration authorities are now reviewing whether a person has enrolled in language classes, attended community language programs, or engaged in activities that show they are making an active effort to improve. Failure to provide evidence of progress, such as certificates, attendance records, or community involvement, can be seen as a refusal to integrate. In some cases, even people who've lived in Australia for 5-7 years have been told they may not meet the new standards if they cannot demonstrate basic communication skills in English. This policy is especially affecting older migrants, stay-at-home parents, and individuals from non-English speaking backgrounds who may have limited access to formal education. With enforcement beginning this October, it's more important than ever to take English learning seriously, not just for communication, but to protect your visa and future in Australia. Number 7. Visa cancelled due to partner breakups. It's a harsh reality that many people don't see coming. A breakup could lead to deportation. Under Australia's updated immigration policies, effective from October 2025, individuals holding partner visas, especially those in the temporary or provisional stages, are at serious risk of visa cancellation if their relationship ends before their visa is fully granted or made permanent. This rule has existed for some time, but the new changes make enforcement much faster and stricter. Immigration authorities are now taking a closer look at the genuine nature and duration of relationships, and if a breakup occurs before your visa is finalised, you may no longer meet the criteria to stay in the country. Many people wrongly assume that once they've received their temporary partner visa, they're in the clear, but in reality, that visa is conditional. It depends on the ongoing, genuine relationship with their Australian partner. If that relationship ends, so does the legal basis for staying in Australia. Even worse, some breakups don't happen by choice. Relationships may become abusive or unsafe. While there are protections in place for victims of family violence, navigating the system can be complex and emotionally draining, and if you can't prove abuse or other exceptions, the default outcome is often visa cancellation. This is especially common among international partners who may have moved to Australia, left their jobs or families, and now face the fear of being sent back alone. The October 2025 updates also give immigration authorities greater access to relationship histories, including social media activity, joint finances, and cohabitation records. If there are signs that the relationship was short-lived or lacking evidence of commitment, even previously granted visas may come under review. In short, partner breakups can now carry serious immigration consequences. Being informed and prepared is more important than ever. Number 6. Failure to meet health requirements. Under Australia's updated immigration policies rolling out in October 2025, failing to meet the country's strict health requirements could now result in visa refusal, cancellation, or even deportation, and the criteria are tougher than ever before. Historically, health checks were a standard part of the visa process, especially for long-term stays or permanent residency, but now authorities are going beyond initial screenings. Ongoing health monitoring, especially for those on bridging visas, temporary protection visas, or awaiting permanent residency decisions, has become a new focus area for immigration compliance. The government's concern, the cost to the public health system. If a visa applicant or holder is diagnosed with a condition that's considered likely to require long-term medical treatment, particularly if it's seen as too expensive or places a significant burden on healthcare services, their visa status can be affected. This includes serious communicable diseases like tuberculosis, but also extends to chronic conditions such as kidney disease, cancer, HIV, mental health disorders requiring ongoing care, or disabilities needing government support. Even if the condition is manageable, if it's likely to lead to ongoing healthcare costs, it can be used as grounds for refusal or removal. In some recent cases, applicants who were previously granted visas were reassessed during renewals or transitions to permanent residency and found to no longer meet health criteria due to changes in their medical status. This has led to shock deportation notices, especially for families with sick children or elderly dependents. The updated rules also apply to dependents listed on a visa application. If one family member fails the health assessment, it could jeopardize the entire application. While there are exceptions and waive is available in some cases, they require extensive documentation, legal support, and time, none of which are guaranteed to result in approval. Under the new framework, your health is now directly linked to your right to stay in Australia. Number 5, misrepresentation or fake documents. One of the fastest ways to face deportation under Australia's October 2025 immigration reforms is through misrepresentation, even if it happened years ago. Whether intentional or not, submitting fake documents, providing false information, or withholding important facts can now result in immediate visa cancellation and removal from the country. This includes things like forged payslips, fake work references, incorrect employment history, or fabricated academic qualifications. But it's not just about forged papers. Even exaggerating your English skills, hiding a previous visa refusal, or failing to disclose a past criminal conviction can be considered deception under Australian law. And here's where it gets even more serious. The Department of Home Affairs has access to advanced verification systems, including data sharing agreements with foreign governments, education institutions, and financial institutions. So if something doesn't add up, the system can flag your application for investigation, even if your visa was already granted. One of the more concerning changes in 2025 is the push to re-examine old visa applications, especially those filed during periods of lax oversight. This means that even if you've been living in Australia for several years, your original documents and application history could be reviewed. If any discrepancies or falsehoods are discovered, your visa status may be revoked without warning. Some people claim they were unaware their migration agent used fake documents, but under Australian law, you are fully responsible for the information submitted on your behalf. Claiming ignorance usually doesn't protect you. Even minor misrepresentations, like saying you worked full-time when you only had part-time hours, can be used as grounds for cancellation if it's deemed that the truth would have changed the outcome of your visa application. In today's environment, honesty is not just the best policy, it's the only one that will keep you in the country. Number 4, social media activity flagged as risky. In the digital age, your online behaviour can speak louder than your official documents. And under Australia's October 2025 immigration reforms, even your social media activity could be enough to get you deported. Yes, you read that right. Immigration authorities are now using AI-driven monitoring systems to scan public content on platforms like Facebook, Instagram, Twitter, X, TikTok, and even WhatsApp groups. The goal? To identify individuals whose posts, likes, shares, or comments suggest a connection to radical ideologies, banned groups, or behavior seen as a threat to public safety. But the criteria are often vague. In some cases, visa holders have faced investigation or cancellation notices simply for liking a political post, commenting on controversial topics, or being part of social groups linked to high-risk regions. And since the system relies on AI pattern detection, context doesn't always matter. A joke, meme, or emotional rant could be misinterpreted as evidence of radical views. Even passive activity, like following certain pages or being tagged in photos from controversial events, can raise red flags. Authorities are particularly focused on individuals from countries with known instability or those on temporary protection, student, or bridging visas. What's more, once flagged, immigration doesn't need to prove that you've committed a crime. If your online activity is viewed as inconsistent with Australian values or a potential risk, your visa can be cancelled under character grounds. This new surveillance approach is already being used in several high-profile deportation cases, with immigration officers citing social media screenshots as part of the evidence. In this environment, your digital footprint matters more than ever. So if you're on a visa, treat your social media like an extension of your visa application. Anything you post could be used against you. Think twice, post smart, and protect your future. Number 3, breach of work restrictions on visas. One of the most common and costly mistakes visa holders make in Australia is violating work restrictions attached to their visa. And with the new rules coming into effect in October 2025, even a small breach could now lead to immediate visa cancellation and deportation. Many temporary visas, like student visas, working holiday visas, and visitor visas, come with strict limits on the number of hours you're allowed to work, the type of job you can do, and where you can work. But what most people don't realize is that immigration authorities are now using automated data matching systems to cross-check your work history against ATO records, bank transactions, and superannuation contributions. That means if you're working even slightly above your allowed hours or getting paid in a way that doesn't match your visa status, you could be flagged by the system and deported with little warning. Take international students, for example. While they may be allowed to work up to 48 hours per fortnight during study periods, some take on extra shifts to cover rent or living costs. Unfortunately, that extra income, no matter how small, is traceable and can trigger a compliance breach. Even unpaid or volunteer work can become an issue if it's considered to be replacing paid employment or doesn't align with your visa type. And if you're on a visa that doesn't permit work at all, like a tourist visa, any form of employment, paid or unpaid, can result in an instant visa cancellation. With employers also facing stricter penalties, many are now reporting workers they suspect of breaching visa conditions to avoid legal consequences themselves. The message from immigration is clear. If your visa says limited work rights, stick to them exactly. Because in 2025, there's no such thing as a harmless side hustle when your immigration status is on the line. Number 2, criminal convictions. No matter how minor. In Australia's updated immigration landscape, even minor criminal convictions can now trigger immediate deportation, thanks to stricter enforcement measures coming into effect in October 2025. It doesn't matter if the offence happened recently or years ago. If it appears on your record, your visa could be at serious risk. Many people assume that only serious crimes like assault or drug trafficking lead to deportation. But under the character test outlined in Section 501 of the Migration Act, even non-violent or low-level offences like shoplifting, drink driving, or a fight in a pub can result in visa cancellation. What's changed in 2025 is the lower threshold for triggering reviews. Immigration authorities are now taking a zero-tolerance approach, meaning that even a single conviction, regardless of how small or whether a jail term was served, can mark you as a person who fails the character test. Worse still, you may not even be convicted in court for this rule to apply. Simply being charged with an offence or receiving a police warning can be enough to trigger an immigration review. The law allows the government to consider your past behaviour, associations, and potential risk to the community, even without a formal conviction. Temporary and permanent visa holders alike are at risk, especially students, skilled workers, and residents on partner or protection visas. And once your visa is cancelled on character grounds, it becomes very difficult to appeal or return to Australia in the future. Many people are deported without realising how serious their situation is until it's too late. That one bad decision at a party, a misunderstanding with police, or even an unpaid fine that escalated to court can now become grounds for removal. In today's system, staying in Australia legally isn't just about following immigration rules. It's also about maintaining a clean legal record, no matter how minor the offence may seem. Number 1, visa overstay. Even by a few days. It might sound unbelievable, but under the new immigration rules, starting in October 2025, overstaying your visa by even a few days could now lead to automatic visa cancellation and possible deportation. Gone are the days when short overstays were overlooked or handled with a simple warning. The system is now strict, automated, and unforgiving. With the rise of digital tracking and AI-powered compliance tools, the Department of Home Affairs can now detect overstays in real time. The moment your visa expires, the system flags your status, sometimes within hours, and begins the cancellation process. And once your visa is cancelled, you're considered an unlawful non-citizen, which means you're no longer entitled to stay in the country. And in some cases, you can be detained or banned from reapplying for years. People often overstay for reasons that seem harmless. Missing a flight, forgetting a visa renewal date, waiting for documents, or just being unaware of the expiry. But under the new regulations, intent doesn't matter. Overstay by 1 day or 10 days, and the consequences can be the same. What's even more worrying is that short overstays can now impact future visa applications. Once you've breached visa conditions, immigration authorities may label you as a compliance risk, making it harder to obtain another visa, even if you leave voluntarily and try to return later. Bridging visas and extensions are also being monitored more closely, with stricter timelines and requirements. Any lapse between visas, even during transitions, could be recorded as an overstay. The message is clear. Under the 2025 policy, there is zero room for error. To avoid accidental overstays, visa holders must set reminders, track expiry dates carefully, and take early action to extend or transition visas, because even a single day late could mean the end of your stay in Australia. As we've seen, the October 2025 immigration changes are not just policy updates, they're a major crackdown that's already reshaping how visa holders live, work, and stay in Australia. From overstaying by a few days to being flagged for social media activity or minor legal issues, the threshold for deportation has become much lower, and the margin for error is now razor thin. These new rules are being enforced with the help of advanced technology, AI-driven monitoring, and real-time data matching across multiple systems. That means your visa status can be reviewed and even cancelled without prior warning, often based on things you didn't realize were violations. The key takeaway? Awareness is your best protection. Knowing the risks, understanding your visa conditions, and keeping your records clean and up to date is now more important than ever. Whether you're a student, skilled worker, partner, or long-term resident, the smallest mistake could have life-altering consequences under the new system. Stay informed, stay prepared, and if you're ever unsure, seek professional immigration advice before it's too late. Because in 2025, compliance isn't optional, it's survival. And remember, what you don't know can get you deported.